Good morning, everyone. My name is Judge Seema Patel. We're here for a hearing in 21-246, Jennifer Janssen-Rogers versus the Department of Energy, Great Lakes and Energy. Can I get appearances on the record for the parties, please?
Good morning, Your Honor. I'm Nick Colson. I am one of three co-lead counsel for the plaintiffs that Judge Shapiro appointed, and I will be arguing for the plaintiffs today.
Great. Nice to
Good
meet
morning,
you.
Your Honor. I'm Mark Chalice, one of the other co-lead plaintiffs' counsel. I don't plan to say a word today.
Mr. Dunleavy, we cannot hear you, or at least I cannot hear you. I cannot hear you.
How about now?
Yeah.
I think I could hear you. Yes.
Okay, my helicopter headphones. Good morning, Your Honor. Wilson Dunleavy, Leif Grazer, Hyman, and Bernstein, also on behalf of the Brazil plaintiffs.
Okay.
Good morning, Your Honor. Nathan Gamble on behalf of the state defendants.
Good morning.
Rebecca Smith, also on behalf of the state defendants. Nate will be doing the arguing this morning.
Okay.
RN also joined by Andrew Granda, who is a law student that is working in our office this summer. I hope the court does not mind that he listens in.
That's wonderful. I hope it's an educational experience. Just so that everyone is also aware, I have my staff who are watching remotely, but they are not shown in the gallery. So with that, we're here for plaintiff's motion to compel. Mr. Colson, please go ahead.
Thank you, Your Honor. With Your Honor having been relatively recently reassigned the case, I'll try to give at least some limited relevant background to how we got to where we are today. But to summarize where I'm going to go with this, Your Honor, I think this is the most outlandish litigation tactic that I've ever had the occasion to address. And I mean that without typical plaintiff lawyer hyperbole. The state is asking this court to endorse the creation of a massive and unprecedented barrier to the vindication of poisoned citizens' constitutional rights that it has just invented out of absolute thin air. In my view, it's offensive to our system of justice, to responsible governance, and to fundamental decency. And unless the court grants our motion, I believe that it would send a tidal wave throughout the state where litigants will be incentivized to engage in this type of obstruction and, frankly, ransom seeking. So the defendants call what they're asking for in their opposition to our motion ordinary negotiations for high-cost discovery cases. Anyone who practices in complex litigation knows that isn't true. But at a minimum, if the state's position here were a credible one, one would expect some court somewhere to have addressed this argument in the favor of the party who's raising it. But the defendants can't cite to a single example of any court anywhere taking an argument like this even remotely seriously. And so, therefore, one of two things is true. Either countless lawyers across the entire state are essentially committing malpractice by failing to protect their clients' interests in costly document productions, and then also producing documents that they'd never need to produce because the other side would never be able to pay for them, or the state's lawyers are just utterly making this concept up for improper purposes. So by way of very brief background, I think there are some disagreement in the moving papers back and forth about the particulars of some of the history of this case. And one of the things that the defendants say is that, well, they haven't resisted discovery. It was this very important concern of the courts that discovery be lined up with some of the cases that were going on in federal court at the time. The defendants moved on January 19th of 2023 for a protective order. And in the briefing on that motion, they explicitly asked the court to revisit its prior decision to allow us to proceed with discovery, or at a minimum to seriously limit the scope of the discovery that we would be able to seek. It's the defendants who jumped up and down and said, you have to wait for the federal court. You have to wait for the federal court. You can't allow these plaintiffs to proceed. We can't have discovery. And on February 24th of 2023, Judge Shapiro granted that motion in part and denied it in part. We were allowed to serve a single, very, very limited set of requests as to specific communications by state actors with the plaintiffs. The discovery requests that we're dealing with here are the first sort of full main set of requests for production that we've had in this case. It's a case that's been going on for several years now. We have not had the opportunity to move for class certification because we've received no substantive discovery of any real note. But during that time, we have been bombarded with motions by the state that have largely been unsuccessful. So in addition to moving for that protective order, they also filed for a motion for a more definite statement, a motion to deem allegations admitted, a motion to compel more complete disclosures, and a summary disposition motion, which they're presently seeking appeal from the Court of Appeals on. And so while we've been able to gather no evidence, the state is taking shot after shot after shot after shot and trying to defend itself, while claiming that its primary interest here is the preservation of taxpayer resources, and that's why they want the victims of the state's constitutional violations to pay $150,000 for their own lawyers and support staff to review documents that they've already collected. So that argument, the financial motivations for that argument are a little bit difficult to take seriously, given the extensive efforts that they've made while preventing us from obtaining any documents to try to get rid of this case. But I want to focus, that sort of goes over, I guess, some of the contested history, but I want to focus on what the defendants don't dispute. They do not dispute that they have already collected the documents that they agreed that they would produce. They do not dispute that they agreed to produce them. They do not dispute that they are demanding payment of $150,000 to review them for relevance and privilege before they will produce them. Now, this is an important issue. They say that they're demanding the payment in their response papers from plaintiffs' counsel and not from the plaintiffs themselves. But in Michigan, our rules of professional conduct tell us that costs always have to be the ultimate responsibility of the clients. Lawyers can advance those costs, but we cannot take the responsibility, the ultimate responsibility away from the clients. And so they're asking this handful of people from a disaffected community that's been lead poisoned to pay $150,000 in lawyer and support staff fees to review these documents that they've already collected. And the fact that they say they want the lawyers to pay it or the lawyers to put the money up is a distinction without a difference that's designed just to obscure how offensive what they're asking this court to do is. A couple of other just very brief points that are overarching, Your Honor, is that the defendants say that the court should deny the motion to compel and instead require the parties to attempt to negotiate a resolution of this dispute. And so it's interesting that in their response, they don't really firmly take the position that the court can and should order us to pay $150,000 for them to review these documents because they know that it's not a non-starter. They're really just trying to use that position as a bargaining chip in order to continue to delay the litigation, to limit what they have to produce to us, and to prevent us from getting the documents that we need to move for class certification and prove the case on the merit. So the idea that the court should somehow compel us to negotiate, where our position is the reasonable one that's the result of a long-standing negotiation between the parties, and theirs is a complete legal fiction invented out of thin air, it's just not, it's not possible. There is no negotiating with a position like theirs. And negotiation of any sort can't require the plaintiffs to agree to something in between what they're entitled to and the defendant's made up position. They assert that the motion is premature, but the record is replete with the fact that we met and conferred with the defendants. We tried to negotiate with them. We thought we had a deal. We then tried to negotiate again once they dropped this bomb after the deal had been reached. In other words, once a deal was struck, the real negotiations began from their perspective. And they were unwilling to budge on this position. So there is no further negotiation to be had on this.
Mr. Coulson, your points are well heard. I have a couple questions about what the defendants raised in terms of already the plaintiffs already having access to a lot of these documents publicly available, and that there have been through the Senate Oversight Committee, like the documents that were produced, some of them were very mirrored the discovery request that the plaintiff has asked. So what is your response to their argument that there are a lot of these documents already available and that plaintiffs need to somehow provide a more curtailed and specific request for documents?
Sure, Your Honor, and I appreciate the opportunity to address that because I think it's an important point here. So there was an assertion made throughout the defendant's papers, not just as it relates to those documents, but a number of other things where the defendant purports to know what plaintiffs or their counsel have read. As we stated in our reply, we have looked through those documents. We have reviewed them in extensive detail. And if the court looks to our opposition to the defendant's motion for summary judgment, we use those documents extensively. So we know what's there. But the idea that they've already complied with some requests, and we set this out side by side in our reply brief to compare what was requested by the legislature and what we've requested. And the idea that they have produced some subset of it relieves them from their obligations to give us a more complete set of documents is just inconsistent with the court rules. And so we're entitled to know that we've got a full set of documents and what else is out there. And the fact that they may have produced some subset of that already actually cuts against the defendant's position because those are not things that they need to further review for privilege or responsiveness. They've already produced it. So any argument that there's privilege there is plainly been waived. So
that's a question I plan to ask Mr. Gamble as well.
Thank you, Your Honor. So yeah, so the idea there that somehow that production gets them off the hook as to their obligations here, I think is just not a serious one. And the other thing on that note that I would argue is they take the position that this production of 91,000 documents is just enormous and so burdensome and so disproportionate. And that's not consistent with what happens in complex cases. 91,000 documents in a case of this magnitude is not an enormous document production. In fact, you get much larger productions in cases of much smaller scope and scale and significance on a regular basis. And so the idea that this is some particularly onerous thing that requires special treatment from the court that departs from all established precedent, we just don't understand.
Okay. Anything else at this moment?
I think, Your Honor, that addresses the broader points. I would just also add that we recently had to stipulate to extend the class certification because
I saw that. Yeah.
refused to produce this. And Michigan has an aggressive policy on when class certification motions are to be heard. It's one of the most aggressive in the country in that it's supposed to be filed within 90 days of the filing of the complaint. And obviously, in most instances, that has to be extended somewhat to allow for the conduct of sufficient discovery to make a record for the considerations under Rule 3501. But here, we are several years into the litigation. We've been unable to get any of the documents that we need. And it would be a real shame for these people who continue to suffer ongoing harm. This is not a situation that's been fixed. I mean, we're seeking, for example, medical monitoring relief. That is an important intervention for the children of Benton Harbor. And every day that this case gets delayed is a day that their opportunity to at least have a shot at that kind of relief becomes less meaningful and less impactful for them because they're continuing to suffer the further down the road we get. So it would be, in our view, very unfortunate to have to adjourn that or other significant case deadlines again because the defendant continues to obstruct us. And so we would just ask that in granting the motion that the court forcefully remind the defendants of their obligations to comply with discovery, to not continue to obstruct the proceedings, and to allow this case to go through an orderly progression so that they can raise their defenses and that we can argue our claims.
Okay, thank you.
Thank you,
Mr. Gamble?
Thank you, Your Honor. The legal issue here, I think is pretty well briefed. I don't think there's really any question that the court has the authority to allocate costs. But just to be clear, the defendants aren't the one who have filed a motion to compel. We're not asking.
I have a question about the cost. What is your response to a plaintiff's argument that there's a distinction between costs related to accessing ESI versus going through and doing the document review and the legal analysis of whether these documents are responsive or subject to privilege?
Our position is...
Go ahead.
I'm sorry, Your Honor. Our position is that the rule changes that that Michigan put into place a few years ago updated e-discovery practices to bring them in line with the reality of e-discovery, that the only expense isn't involved in, going through old, outdated electronic storage devices or something like that. There's a massive expense involved in every aspect, and the rules, including the guidance that the plaintiffs themselves cite, explicitly confirm that the state court rules allow for the allocation of expenses, not just for the accessing and looking for ESI, but for other aspects of ESI discovery, including review and production. So that's our legal position. And really, as we've tried to explain in our briefing, from our perspective, this is a practical problem that traditionally with most other plaintiffs were able to resolve through negotiations. I have never seen or met Mr. Dunleavy. This is the first time I've seen him or heard his voice, yet this is someone who we've been exchanging letters with. I've tried to set up meetings several times, and the plaintiffs have rebuffed that request. We've had one meeting last October for about an hour with two of the plaintiffs' attorneys. So really, this is traditionally something we're able to work out, but the plaintiffs have taken a really aggressive posture here, saying we want basically every conceivable Benton Harbor related document for these huge state agencies dating back to 2016. And we've tried to explain that that's a pretty significant undertaking that can get pretty expensive. And they said, that's what we want. So we said, well, look, this is 91,000 documents. If these are going to get reviewed anytime this calendar year, we don't have the staff to be able to do that in a prompt way. We're going to have to hire out, and it will cost this much money. Or, is this something you're willing to pay for? Because the defendants, we try to take seriously stewardship over public funds. And
well, I will say that I think I'm not sure I find your argument that the review of relevance and privilege is a cost that can be allocated under 2.302B6. My interpretation of that court rule is that it deals with the cost of accessing the ESI. But my question for you is, in your brief, you laid out that a lot of these documents, I mean, the state has already gone through a pretty extensive process of finding these documents and making them available for the Senate Oversight Committee. And that in doing that and finding responsive documents, like a lot of this work has been done in terms of finding whether it is relevant and privileged because it's been publicly accessible. What is the hurdle and economic burden that you're claiming to then providing some of these same documents? And maybe there's more of them, maybe there's overlap, I don't know, but like for a lot of them, that work has already been done. So what is the argument that that's going to be duplicative work or add to the state's burden? Because it seems like you've already got a jumping off point in terms of that much has already been done in terms of the discretionary.
Well, what the defendants have, or excuse me, what the plaintiffs have asked for here is to recollect all of this that has already been done. I don't know if they don't trust the process that was taking place. They've suggested it was just voluntary. It was not. It was pursuant to a demand by the Senate Oversight Committee, which we don't see as voluntary. So the reply brief that the plaintiffs filed is the first time that they have suggested they're willing to forego the review and collection of documents that have already been reviewed and collected. That's why in our response brief, we lay out in great detail how these two things overlap. That to me is a positive step forward that probably could have been achieved through negotiation without the court's involvement. So there are several options that we could take at this point. So for example, the search that was done for the Senate Oversight Committee only dated back to 2019. The plaintiffs want to go all the way back to 2016. So if we redo that search, but instead of starting at 2016 and then up to 2021, we just do 2016 and 2018, that's probably going to pare back significantly the number of documents rather than having to redo the stuff that's already been done. There are a few other options, you know, rather than do a search of the Senate Oversight Committee custodians again, what if we just limit it to the other much more minor limited players here who may have been copied on email or something like that, and limit it to the custodians that weren't already searched. So again, these are all things we could have been negotiating with, talking about.
This is just a question for me, and it might be because just new in terms of the discovery requests. But if you were responding to their discovery requests and you made a assertion that we're providing these documents that were populated previously from 2017 to 2018 forward based on what we did for the Senate Oversight Committee, you would provide them again in the context of the discovery here, but with an explanation that it was already previously collected, and then explain the new documents and the search. Is that because I do understand they're in discovery, I think that plaintiffs do have a interest in getting these documents from you and your client from the state as a part of discovery, right? Because there are protections and consequences that come with a discovery response, and in the context of this litigation, that the same protections may not apply to just what is publicly available at a website. And so I understand that concern of theirs. Is there a way to marry that concern with you not having to duplicate work that you've already done, but then just additionally add on to make the full response to what they are seeking?
I think so, Your Honor, if I understand your question correctly. This is something Mr. Dunleavy raised in one of his letters, and is part of the reason why we assumed that the plaintiffs had not actually reviewed the letters, because the letters and the website, they explain what the search terms were, who the custodians were, and one of the protections that isn't available, like under FOIA, for example, but is in discovery, is a privilege log, is traditionally available through discovery. Well, Eagle did a privilege log with these documents. And so there is a publicly available privilege log that they hadn't been aware of that we were able to share with them. So that's the type of protection that is available already for the plaintiffs. And so if we're able to do the same search, the same custodians, but just with the wider time frame, so for the years that haven't already been searched, like I said, that's something that can probably cut down big time on the number of documents that need to be looked at again. And so, those aren't the only options, you know, there are others.
And would you be willing to certify on behalf of the state that what was done previously was a full and complete production of responsive to those inquiries?
Responsive to the Senate Oversight Committee's inquiries?
Senate Oversight, and also the plaintiffs' current inquiries.
Well, that's one of the open questions here that we're hoping to get a response from the plaintiffs about, which is, what is it that the Senate Oversight Committee did that you don't think is sufficient? So they have what the Senate Oversight Committee requests were. They have what the what the search terms were, who the custodians were, the time frame. They have all of that. And so tell us what's not okay with that. Because yes, it already has been certified by our clients in the letters that we've forwarded to the plaintiffs, confirming that they have fully complied with the Senate Oversight Committee's requests, and this is how, in great detail. So yeah, we absolutely will stand behind that. So if what the plaintiffs want is they're not satisfied with that, give us a more targeted request rather than just all documents about Benton Harbor for the past 7 years.
That might come.
So
sorry,
it's so heavy-handed. That's the point we're trying to make. We try not to just casually spend so much public money. It's not ours. And so if there's a way that we can pare this back, give the plaintiffs what they want, have them explain to us what was wrong or what was incomplete about the Senate Oversight requests. I mean, we lay out in our response brief side by side, explaining that these appear to overlap from our perspective. So if they want us to just go back and do the two.
I mean, to the extent that someone's going to have to make I would put that burden on the state, because I did find your chart very useful in terms of laying out what the Senate Oversight Committee response or request was and what the plaintiff's request was. But would you and the state be willing to certify that the documents that were produced in response to the Oversight Committee are fully also responsive to what the plaintiffs are requesting.
Oh, I'm sorry. I understand your question now, Your Honor. So,
and you don't have to answer right away, but that's something I want you to keep in mind, because if we're moving forward to figuring out how this discovery is going to be produced, and I fully understand your concern about not wanting to reinvent the wheel, so to speak, but I also want to be very careful and ensure that the state is providing full discovery responsive to the plaintiff's requests.
So in my opinion, Your Honor, and we've tried to make this clear in the briefing, we've tried with the plaintiffs unsuccessfully so far to set up meetings to negotiate. I think there's a way to satisfy the exact concerns that you're raising, which is figure out, confirm with them what they're unhappy about or what they're not satisfied with the existing documents that they have. It's not clear to me still that they really have a handle on what those are because of the letter exchanges we've had. And then do some more targeted searches rather than such broad, heavy-handed ones to try and get to the stuff that hasn't actually been produced yet and see how much of it there is and go from there. And so, I think that's a pretty reasonable way to keep us out of court, to be completely honest, is to just have us figure out how to do this and only bring the dispute to the court when it's truly sharpened and it's really clear what's missing still. And to me, it's not clear what's missing still. They have a lot of documents. And so I think there's a way to do this that doesn't cost so much money.
Okay. Thank you, Mr. Gamble. I may come back to you. Mr. Colson, what is your response to anything that Mr. Gamble had to say, or my perspective relief that I'm thinking about?
So, Your Honor, first of all, we're not interested in making them re-review things that they've already reviewed for relevance or privilege. I mean, that's part of the argument that we're making, is that they don't have to do that because it's already been done. But I think Your Honor honed in on the exact issue. We would be willing to accept a certification that what they're going to produce and review satisfies our requests. However, that's not what we just heard Mr. Gamble say. What Mr. Gamble wants us to do is identify whatever documents that we might not know about that they haven't given us. That's not possible, and that's not how discovery works. The burden is on the responding party in discovery to go out and figure out what is the universe of responsive documents, and then to produce them unless they're protected by privilege or there's some other reason they don't have to produce them. And so we can know what's been produced, but we don't know what other documents are out there. Only the state can possibly know that. And so I think that's the fundamental issue here, is that they're making this about the cost of reviewing these things for privilege and responsiveness. But what they really want to do is to have us change the scope of the requests. But they didn't go about it the right way. They didn't move for a protective order. They didn't raise this issue at any point during our prior negotiations when we voluntarily agreed to limit the scope of many of our requests. They waited until the end, and then they tried to use another hook to get us to go back and further refine our requests by asking for specific documents that we have no way of knowing about. And that's just not how discovery works, Your Honor. They want us to do a targeted search for things that are in the state's exclusive possession, custody, and control. That's their job. It can't be ours.
Okay. Mr. Gamble, I find a plaintiff's argument to be persuasive. At the same time, I am very aware, and I do not want to make the state reinvent the wheel and do work that has already been previously done. But I do find that the state is the one that needs to be able to certify that if in these previously produced documents or previously available documents that they would then produce again under the auspices of a discovery response, that they are responsive to plaintiff's discovery request. Is that something that at least partially addresses the state's concern about reinventing the wheel?
I'm sorry, Your Honor, having us certify that the Senate Oversight Committee requests, and we haven't talked about in the hearing, but we talked about in the briefing, the FOIA responses that are available online.
So
satisfy the existing discovery requests?
And I could be mistaken, and if I am, please feel free to educate me. But The way that I'm conceptualizing this is that the state has already gone through the process of populating its responses to the Senate Oversight Committee and populating its responses to the FOIA requests, and that these documents exist. They've gone through whatever processes the state had to go through with them, and the state is arguing that these documents are, to a large extent, if not completely, responsive to what plaintiffs are asking for. So why can you not just take that body of work that has already been done and use it and give it to the plaintiffs in the package of the discovery responses? And by doing that, then you'd also be certifying that these documents that have been previously produced or previously disclosed are responsive to what plaintiff is asking for. And then to the extent that there are years that plaintiff is asking for that go beyond what has already been done, then you can do that.
So we have offered to do that in one extent, Your Honor. Because the documents that are publicly available are in PDF form traditionally, and well, under the current ESI order the court has signed, that's not the format that is compliant with the court order. And so we've offered to reproduce all of these that we have, except compliant with the ESI order. And they haven't responded to that.
I think there's probably two pieces, like reproduce it compliant with the ESI order, but also with the certification that it's responsive completely to the discovery request. Is that something that the state can undertake to do?
Yeah, we can reproduce what we, yes, we've also already offered to reproduce the Senate Oversight Committee documents so that they're compliant with the ESI order. The plaintiffs didn't say one way or the other whether they wanted us to do that. But yes, we are willing to do that. In terms of certifying that they are responsive to the discovery requests, we absolutely can, but their discovery requests are broader than the Senate Oversight Committee. So we can't certify that the Senate Oversight Committee documentation fully responds to their existing discovery request, because
so I think what I'm, at least the way I'm thinking about it, if it is, I recognize that their request is broader, but if it meets 70% of the pie, you can, okay, 70% of it is done, and then you would be responsible for doing the other 30%, correct?
Yes, and that's what I've tried to get to, Your Honor. And so, for example, the years that weren't searched as part of the Senate Oversight Committee, we can do a search for that for 2016 and 2017 and 2018, because the Senate Oversight Committee was only 2019, I think, to 2021. So we can do that. I'm not pushing back on that, Your Honor, but the way that this dispute reached the court, none of those agreements had been reached yet. And so that's traditionally something that we would try to negotiate beforehand. But yes, that is something that we're willing to do.
Okay. Mr. Coulson, anything that you want to add before I...
Your Honor, I'm not sure I heard a commitment there to, there's sort of this issue of bridging the gap between the prior production and our requests temporally, and by tacking on those additional years. But I don't think I heard a commitment there by the state to address the gaps in the substance. And I think that's what Your Honor is pointing to and what we've been requesting. So, for example, if you look at the table on page 11 of defendant's response, as Mr. Gamble just acknowledged, our requests are significantly broader in many instances than the prior productions were made under. And so, for example, the bottom of page 11, we've got 3 different requests that are in many ways broader than the correlated legislative requests. And I don't think I've heard a commitment from the state that, yes, they're going to go out and ensure that all of the gaps between what they've produced and what we've requested are filled. And my understanding of what the court is suggesting is that that is the appropriate course of action, and that's certainly our position.
Mr. Gamble?
I think that that's something that we can talk about and negotiate. For example, we can talk about the search terms that were used for the Senate Oversight Committee requests. Mr. Coulson has all of those. He should see that they're pretty broad. So applying those search terms just to a different chronological date might satisfy them, And so I guess my point is, Your Honor, we are absolutely willing to work with the plaintiffs to figure out a way to tailor these so that they're more responsive without having to reinvent the wheel. We've been trying to do that. And so I don't know how the court could phrase an order. I mean, I think from our perspective, it would be...
I'm going to take
Right.
the council up on their both sides offering to work together. I am going to grant plaintiffs a motion to compel, and I'm going to ask the parties to confer together, whether by Zoom or phone call, and draft a stipulated order on plaintiff's motion to compel, outlining the paradigm that I've set forth here today, which is that the state does not need to reinvent the wheel for the work that has already gone in populating the responses and the documents that were done for the Senate Oversight Committee and FOIA, but that the whatever the state does after putting it into ESI searchable format and in keeping with the court's ESI order, and then whatever additional work needs to be done to make sure that the previous years and any gaps that there are in what was produced for the Senate Oversight Committee and what plaintiffs are requesting is met. Is that acceptable?
It is, Your Honor, and I just want to make clear so that we don't have a dispute about this between the parties. The court is ordering that paradigm based on the requests as they are written without a directive to the plaintiffs to renegotiate or rewrite the requests themselves. Is that correct?
Currently, yes. And but I will put the caveat in mind that to get the ball moving forward, if the parties can work together and figure out what paradigm to set up or what parameters to set up to meet the requests, I would do that. Otherwise, you may file a motion and I will see you all again. Is that acceptable, Mr. Gamble?
Yes, Your Honor. I mean, it's the court's order. We will certainly comply with it. So we can work together and work on a stipulated order to hopefully tailor this a little bit more effectively.
Okay. And then if I give you guys a week to come up with the stipulated order, is that acceptable? Keeping in mind that I know that next week is the Memorial Weekend. Will that be enough time to come up with a stipulated order to submit to the court?
I think a week should be fine, Your Honor. We'll endeavor to get a draft out to the defendants today so that they've got it in advance of the weekend, and then hopefully we should be able to be well in advance of a week.
Okay. So, Your Honor, perhaps because I'm traveling for work tomorrow, and then obviously the state holiday on Monday, you know, if we could do 2 weeks, I think that'd be a little bit easier. And so that would be maybe by the end of the first week of June, so June 7th.
How about I give you until June 3rd?
June 3rd, okay.
Which gives you a couple more days. And is that okay? Let's see. Sure. Is till June 7th acceptable to you, Mr. Colson?
7th or 3rd, Your Honor? 7th?
7th.
We could live with that, Your Honor.
We can live with that? Okay, I will give you the 2 weeks, Mr. Gamble. Have until the 7th to submit a stipulated order with the court. Okay, is there anything else that we need to discuss right now?
Nothing further from our side, Your Honor. Thank you very much.
Okay, thank you very much. All right. Go ahead, Mr. Dunleavy.
I was just going to say this has been really helpful, and I think we've gained a lot of ground having the benefit of Your Honor, and plaintiffs would be more than willing to have monthly or every 2 months status conferences with Your Honor as discovery appears to now be picking up. And so we just wanted to put that on the record and not formally asking for it now, but just something to keep in mind that I think would benefit the parties here.
Okay, I think that would be a good idea. That actually reminds me of another issue that I wanted to at least put on the parties' radar is that if there is going to be an extensive privilege log done, we may need to think about if a discovery master is needed for when discovery goes forward. I'm not saying like these are issues I foresee coming up, but I just wanted to put that on your radar and see what your thoughts are, at least to start thinking about them.
Okay.
Okay. All
Very
right.
good, Your Honor. At the risk of extending this interminably, and I'm sorry, but there's one more issue I wanted to raise. no part of the court's order is requiring the plaintiffs or their counsel to pay for the defendant's review of the documents.
That is correct. That part of defendant's argument, I do not find persuasive, and I am not going to be shifting that cost onto the plaintiffs.
Thank you, Your Honor.
Okay. All right. Anything else?
Nothing from our side this time. I mean it.
All right. Thank you very much. Have a great rest of your day.
Thank you, Your Honor. You as well.
Bye.